Okay, we still have a lot of people joining. Welcome to our 650 webinar, Hiring in a New State, Avoiding Pitfalls, and What Comes Next. We're going to give people another minute to join. Our numbers are continuing to climb, so we'll just give them another minute to get situated, and then we'll kick things off. Thanks for being with us today. Okay, our numbers are still climbing, but I think that we'll kick things off. So welcome to our 650 webinar, Hiring in a New State, Avoiding Pitfalls, and What Comes Next. My name is Ryan Parker. I'm the Chief Legal Product Officer at 650. And for those of you who may be new to one of our 650 webinars here, 650 is the legal technology subsidiary of the law firm Wilson Sonsini. We take legal expertise and thoughtful computer engineering and create products that help businesses and individuals. And so we're excited to be able to talk today about hiring in a new state. We've been working on a new tool to help companies know all the things that they need to do when they hire in a new state. We also have an employee handbook tool that can help companies to expand their handbooks when they move into a new state, and an employment agreement tool that helps companies to generate employment agreements that are tailored to the requirements in each of the 50 states and the District of Columbia. So we've been thinking a lot about this topic, and we're excited to discuss it today. Before we dive in, just a couple of points that we wanted to make early on. One, we hope this will be an interactive webinar. We're going to ask you some poll questions. We also would ask, if you have questions, that you put them use the Q&A function at the bottom. You put them into the Q&A so that we can answer them and keep track of them. You can also feel free to use the chat to discuss things back and forth. But we're really excited to hear, your questions and get your feedback. And we hope that this can be kind of a discussion format. We always get the question, will we get the slides afterwards? And the answer is yes. We'll send you the slides, and we will also send you a recording of the webinar, so you can watch it later, or if you need to leave early, you can catch the end of it. There will be a CLE code. We will not be able to send that to you later. So with the CLE code, you have to be present, and we will read that out later in the webinar. You can write it down to use to get your CLE credit. So we'll do that here shortly. But we're excited to talk about this interesting issue that I think a lot of businesses are facing: hiring in a new state. Before we do that, I thought I would just make a quick announcement. One of the things that we do at 650, in addition to our commercial tools, we work hard to build what we call pro bono tools, free tools that make the law more accessible for those in need. And we're really excited today. We're actually, in fact, I think there's a press conference right now, but we're releasing a new tool to help Ukrainians who are in the United States to stay in the United States. So we've automated the temporary protective status, the TPS application, and the asylum application, and we've translated it into Ukrainian to help those people. And so that's something we're really excited about. And if you're interested in that, feel free to visit us at 650.com and you can see more about it. Okay, so we'll jump right into the webinar. Let me give you just a look at the agenda. First, we're going to talk about must-do evaluations and state-specific hiring laws. And that'll give you a little bit of an overview of some of the different issues that companies need to grapple with when they're hiring employees in new states, or when they have current employees who want to move to new states where they don't already have employees. Then we'll talk about some specifics, like how to fulfill state registration, tax policy, and other obligations. And finally, we'll turn to notices and information for your employees that you need to have based on the state that you're in. And so we'll kind of start broad, and then we'll get a little bit more specific in the things that we're going to cover. So I'm an attorney, and as an attorney, I love hypotheticals. So I'm going to start with two hypotheticals that I have here on the next slide. The first is this one. A current employee comes to you and wants to move to a new state where you do not currently have employees. So think about that hypothetical. A second hypothetical: a team leader comes to you and wants to hire a new employee in a state where you do not currently have employees. So these are kind of the two major scenarios where you have to think about expanding your workforce into a new state. And we're going to talk initially about what you should be thinking about when you are deciding to expand your workforce into a new state. And I see Cindy's put in not hypothetical anymore. That actually is exactly what we're going to ask you in our first poll question. Are these actually hypotheticals, or are these issues that you have already dealt with or may be dealing with right now? So we'll pull up our first question, and we're going to ask how many of you over the past 2 years has your organization had to decide whether to expand your workforce into a new state? And that could be because you had an employee that came to you and wanted to move to a new state where you didn't have employees, or if you had a team leader or another person from your organization come and ask to hire someone in a new state. And I'm interested to see our results. I think this number has climbed dramatically over the last 2 years. So let's see what we've got here. We'll pull up the results of our first poll. Wow, that is actually even more dramatic than I thought. So 94% of our answers were yes, that the company has had to decide whether to expand into a new state. Only 6%. And for those who are interested, we had almost, looks like about 70 people participate in the poll. So it's a pretty significant size poll. And almost every company, every attendee here, their company is facing this same issue. So let's talk about the factors to consider in deciding whether to expand into a new state. And for many of you, you've probably gone through this process, but there actually are a lot of different factors. We'll start with cost. It can be expensive for companies to expand into a new state, right? So you've got things like sales tax, income tax, unemployment insurance, workers' compensation, paid leave requirements. And so there can be sometimes significant costs having employees in a new state. And that can vary dramatically from state to state. There are some states that tend to be much more expensive to have employees in than others. Another issue is benefits coverage. You need to look at your benefits plan and see whether it can sustain employees in new states. And we have talked to several companies where that's been an issue, where they the way their benefits were laid out, they really weren't able to have employees in certain states. And so that's an important consideration for companies that are offering benefits to their employees. And I think that's most companies. The next is employment laws. And I think this is one that companies often forget as they kind of get into the minutia of trying to register and do all the other things that they have to do. You know, employment laws can differ significantly from state to state. And I'm going to talk about just very briefly 2 different areas where we see significant differentiation. One is in employment agreements. So in your employment agreements, you probably have a number of different clauses that can vary widely from state to state. For example, most employment contracts in the United States are for at-will employment. But if you have an employee move to Montana, Montana is not an at-will employment state. In fact, I think it's the only state that is not an at-will employment state. And so if you're a California company, and I've talked to several California companies in this position, and you have an employee who's tired of the high cost of living in California and wants to go ski in the winters and spend time in the mountains, and they want to move to Montana, and you've had them sign an at-will employment contract and they move to Montana, you could run into a problem where that contract actually is no longer an at-will employment contract, and you have a contract that's subject to the law in Montana. And that's a tough situation to navigate. And I think one that companies need to go into with their eyes open. Another significant area of significant variation is non-compete clauses. This is one where some states don't allow non-compete clauses, like California. In some states, in fact, Colorado has recently passed a law where if you have a non-compete clause, an inappropriate non-compete clause in one of your employment contracts, you could actually be subject to criminal penalties, a misdemeanor. Washington, D.C. has a law that I think is set to take effect here shortly, where they could fine companies for each employment contract that has an inappropriate non-compete clause. And then other states allow non-compete clauses. And so this is a really important area for companies to think about as employees are moving. If they have a contract where there's a non-compete or a non-solicit clause, for example, and it's permitted in one state and they move to a state where it's not permitted, what do they need to do? Do they need to enter a new employment agreement? I think that's a best practice. But they need to think about how their employment agreements are affected. The next thing is employee handbooks. We talked a little about paid leave when we were talking about the cost, but the employment policies that are required and the type of leave that you're required to give can vary significantly from state to state. And Josh is going to talk more about this issue, but I wanted to just give you a flavor of what this variation might look like. We have a tool that we use to help companies see the differences between states for what policies are required. And I used it to just pull up a couple of neighboring states. So if you're in California, or say you're in Utah and you have an employee who wants to move to Nevada, you can see that there are different policies that are required. And then if you're a Nevada company and you have an employee who wants to move to California, you can see that there are many more required types of leave and policy that you'll need to be thinking about and that you should probably include in your employee handbook. And so the requirements, I think, for employment policies and leave and employee handbooks can really vary drastically from state to state. And Josh will cover this in more detail later. Let's talk about a couple more factors to consider in deciding whether to expand into a new state. One that has been significant in the past is COVID rules and regulations. These can vary wildly from state to state and may require written policies. For example, in California, you have to have a COVID prevention program, a CPP. In New York, for an extended period of time, you had to have a policy based on the HERO Act. And so some states require written policies. Some may also require training. For example, in California, we have a module that helps companies to comply with Cal-OSHA's emergency temporary standards, ETS, and those standards require employees to be trained on different aspects of COVID-19 prevention. And so those are the kind of things that employers should be thinking about when it comes to COVID rules and regulations. And I know that many of us maybe feel like we've moved past the pandemic state and COVID, is something we don't have to worry as much about, but some of those rules are still in place. And, I live in the DC area. We're starting to see an uptick in COVID cases. And I don't think that we've seen the last of COVID rules and regulations. And so the other thing related, we talked a little about training, but notices and training. Josh is going to talk a little bit more about this, but state law may require you to provide different types of notices to your employees based on what state you're in. And that notice can be interesting if employees are remote. There are questions about whether you could post that or email it to them. It used to be that you just put it up in an area where employees would congregate. Often, in my former, where I used to work, it was in the lunchroom. We had all the posters up. How you give notice to employees, I think, is changing. And the type of notice that you have to give can vary from state to state. And the same with training. There are various states that have training requirements. For example, New York requires training on sexual harassment. And so if you have employees that move to states that require that kind of training, if you just have one or two employees, you still have to meet that obligation. You're going to have to figure out the training. I would say before we get to other challenges, an additional factor is just the amount of time and effort that goes into taking all of the steps necessary to have an employee in another state. That can be a resource intensive process as you're registering, and Adrian's going to talk more about that, as you're figuring out the tax consequences. All of those things can be time intensive. There are also some other challenges, like having employees in a different state can also mean different time zones. I'm very aware of that challenge. Most of our team is in the West. We have our headquarters is in Utah, and we have employees in California and Oregon and New Mexico. But I'm in the DC area in Maryland. And so I have a time difference from many of my employees. In fact, I have multiple team members in California. We have a 3-hour difference. And so we have to just make sure that we're scheduling meetings and times that work for us. I actually think it's worked well for our team, but I think it can be a challenge. And then finally, there's the cultural challenges in your company, right? As you expand, as you have more people working remotely, there can be cultural challenges that come along with that, having to hold more meetings on Zoom, having to handle time zones. And I think those challenges are real and are things that companies should think about when they're hiring people in new states. Now, let me say this may look like a list of reasons not to hire people in new states, and that's really not the intent. In fact, in this labor market, we're seeing more and more companies who are hiring people in new states and are allowing their current employees to move to new states. And they're doing it for a number of different reasons. One, it's expensive to replace an employee, and especially a high-performing employee. And so companies are willing to do the work to keep their employees happy and to keep them at their companies. And two, it's a tight labor market. And so replacing an employee or hiring, if you can get a good employee, I think companies are willing to take significant steps and go through, the process that we've talked about in balancing the pros and cons in order to hire the best talent. And I will say for us, we've sort of transitioned to being a remote first company. I'm grateful that my team is spread across a number of different states. We've been able to hire excellent people and not been constrained by their location. And so I do think there are a lot of benefits, but I think states need to go in with their eyes, or I think companies and organizations, need to go in with their eyes open, because if you hire someone in a new state, there are a number of steps that you're going to have to take. And it isn't as easy as just pulling out the employment agreement you've used with all your employees, sending it to them, and you're done. You really need to be thinking through what the implications are of hiring someone in a new state. And that's what we want to help with here. So I want to move to the next poll. We've kind of talked about the things you have to think about. And I'm wondering, from our last poll, we know 94% of our participants had to decide whether to expand into a new state. And I'm wondering how many of our participants have actually refused to allow a current employee to move to a new state, or decided not to hire an employee because they live in a new state. So as you've weighed the different considerations, I guess the question is, have you ever decided that, the cons outweighed the pros and you haven't let someone move, or you haven't hired someone because of the state they live in? I'm really interested in this because I think as companies tackle this issue, I've seen a lot of different approaches, but we have seen a lot of companies that have said, you know what, we're just willing to do what needs to be done to keep and attract the best talent. So let's see what the results were on this one. Very interesting. So we have almost a 50-50 split. About 47% of our respondents said that they have had situations where they have either not allowed an employee to move, or they've decided not to hire an employee because of the state where they live. And 53% said no, they haven't had that situation in their company. And so I think that this type of weighing, looking at the factors and thinking about it, is something that companies are being forced to do all the time. And it's really kind of a new part of, I think, the new way that we're working because of COVID. And I think it's here to stay. And I think that companies really need to think through this. So to wrap up my section, I want to just talk about some really basic strategies to make it easier. We know this is here to stay. So what can you do? One, I would say leverage your current service providers. Reach out to your payroll company, see what they can do for you. Insurance companies, other things. Talk to your current service providers and see how they can help to smooth out the process of hiring in new states. I would recommend that people explore outside tools. This is something that we've tried to work on. We've had a lot of companies that we work with come to us and say, this is really hard. And so we've created some new tools, essentially a checklist that helps companies to know what they need to do in each state. We have a handbook tool that helps companies to update their handbooks, either by creating an addenda for a new state or adding policies into their main handbook. And we also have an employee agreements tool where a company can generate an employment contract for any state or the District of Columbia. And so we've tried to create tools. I think there are other great tools out there. This is a hard thing for companies to do in-house. It can be very time intensive. It's complicated. So I would recommend that people at least look at outside tools. And then once they have sort of gone through this process, they need to create a set process so that they're not having to start again every time this issue arises. Because if you've already had this issue arise, I think it's very likely to continue to arise. And if you haven't had it arise yet, I think it's only a matter of time. employees are wanting to move to places where it's less expensive or they're closer to family. Your teams are going to want to hire people in different markets. So create a process for determining what states you're willing to move into and thinking how you'll balance that, and then create a process for taking the steps you need to do that. And I think having that process in place will allow you to make a more informed decision and will make it easier if you decide to expand into a new state. And so with that, I'll turn it over to Adrian, who's going to dig into some of the details that go along with starting to have employees in new states.
Thanks, Ryan. Deciding whether to allow employees to work in new states or hire employees in a new state is a big consideration for a lot of companies. And then once they've made that decision, then the question is, okay, now what? What do we need to do in that state to make sure that that employee is set up and we're complying with all the laws in that state? And one of the questions that we saw in both the chat and the Q&A is people are asking about, well, what does it mean to really work in a state? Just because they live there, does that mean they work in that state if they're doing administrative work for all of the company's business that's in a different state? And the short answer is yes, they work in that state. Where the employee lives really determines what laws govern that employee's benefits, employment laws, employment policies. That's the governing law, is where the employee lives. So if they're working from home in a completely different state, the company needs to comply with that state's laws, even if they're doing all online work for the company's headquarters in a different state. It's where the employee lives, if they're working remotely, that governs the employment policies in that situation. So once a company decides to hire, one of the first steps is, okay, do we need to register to do business? Many states require companies to register to do business as a foreign employer before that company can obtain different tax accounts or register for different employment authorities in that state. States are grappling with the issue of whether having a remote employee in a state constitutes transacting or conducting business. And those are key words because those are the words that are in the state statutes. Almost every state has a statute or law that says a foreign entity, which is an entity that was not formed in that state, cannot conduct or transact business until that entity has obtained a certificate of authority in the state. And almost every state also has a law that follows that says, here are certain activities that don't constitute transacting or conducting business in the state. And these laws are similar across most states. So they have similar exemptions that we've seen. And these often contain things like maintaining or defending a lawsuit in a state is not conducting business, or holding an internal company meeting of managers is not conducting business. Having a bank account there, selling through independent contractors, creating or acquiring debt in a state, or only owning real property doesn't constitute transacting or conducting business, nor does isolated transactions that aren't repeated regularly. We haven't yet seen a state law that specifically speaks to this issue of remote workers, is a remote worker in the state, if they're an employee for another company, does that constitute conducting or transacting business? That's a big open question. So on the next slide, we've seen some states try to grapple with this issue. In California, for example, the Secretary of State website has this FAQ asking whether a remote employee working in Colorado constitutes transacting or conducting business, such that the company would need to obtain a certificate of authority to be in that state. So this FAQ, as you can see, refers companies to the statute that says you need to obtain a certificate of authority before conducting business. And here is what is not transacting or conducting business. Nowhere in that statute does it say anything about workers working remotely or employees for another company working remotely. So this answer is raising the question, but it's not really answering it. You'll see they say your business is unique. We know that every situation is, or that the Secretary of State can't answer these legal-based questions. So they recommend that companies talk to an attorney. So they're raising the question and not really providing much guidance on it. Is having a remote employee conducting business? So due to this uncertainty, we've seen a lot of our customers err on the side of caution. And that means they register to do business in those states as a safeguard, because it's not entirely clear from the statutes, because they haven't caught up with the new wave of remote working and kind of the new workforce that we've seen that's dispersed throughout the nation. So until the laws catch up and until we get additional guidance, many of our customers are saying, yes, we'll register in that state, which often means filling out a form or an application. having a registered agent in the state. Most of the times it has to be an individual or a business agent, but occasionally the states will say that the state Secretary of State can serve as a registered agent, but most of the time companies need a third-party registered agent to qualify to do business in that state. So we're going to bring up another poll question based on this background where there is so much uncertainty of, is having a remote employee conducting or transacting business? We'd love to know, does your company register as a foreign entity to conduct business in states where you have remote employees? Yes, no, or this is not applicable to your company. Awesome. We're excited to see these poll results coming in. I know this is an issue that I've tried to run to the ground in various states, and there is a lot of uncertainty surrounding it. We'll give that a couple more seconds, and then we'll show the results to that poll. Okay, I think we're ready to show the results. Okay. Does your company register as a foreign entity? 65% said yes, they do. 17% said no, and then this question doesn't apply to 17%. So it seems like you are all taking a similar approach to our customers where they are registering as a foreign employer absent further guidance, which is great to err on the side of caution. We always like to take that approach. So once the company is registered to do business, there are some additional registration requirements. And one of these is registering or reporting new hires to the state. This is often done through the state's Department of Labor, but it can be through other agencies as well. This obligation came from the Personal Responsibility and Work Opportunity Reconciliation Act, which is a federal act, and it requires employers to report data of new hires or rehires within 20 days. The goal of this reporting is to obtain payment for child support orders, since wage withholding is often the primary means to satisfy non-compliant child support orders. And it also helps to prevent fraud in government payments or fraudulent unemployment and workers' compensation payments, because states can then match this data with the information from other states. If it's all reported in every state, then they can match and say, oh, somebody who's obtaining unemployment insurance in one state is actually working in a different state. So the goal of this is to kind of prevent fraud and to ensure support for child support payments. And there are kind of two main ways to do this. One is by reporting the new hire to the State Department of Labor, to each state's Department of Labor as the company hires a new employee. And then another approach is called multi-state reporting, where employers can report this information to one state, and then they need to inform the U.S. Department of Health and Human Services of which state they're reporting to and register to be a multi-state reporter. So they need to make sure they do the registration first, and then it's kind of a consolidated reporting process. But most of the customers we've seen are into reporting each new hire individually to the state authority, which I think is still the most common approach. Other registration things are ensuring that the company has workers' compensation coverage. Only a handful of states like Texas don't require workers' compensation insurance and allow employers to self-insure or just to pay for workers' compensation claims out of pocket. But in those states, there are reporting requirements that the company has to notify the state that they are self-insured and then notify employees of the same information. There are also unemployment insurance registration process, and this is across almost every state. And every state approaches this a little differently. Some states still require a paper mailing to be mailed in to register for an unemployment insurance account, and other states have an online portal where companies can register. And it really differs depending on the state of how complicated or easy is this process. And then something we've seen as we've developed our new tool that helps companies understand all the registration and employment implications of hiring in a new state is that some states make it easier by consolidating the registration and reporting requirements. And there's maybe one place where they can do all of these different registrations. But in the majority of states, it's still individually where the company has to obtain a certificate of authority in one place, report a new hire in a different place, obtain or register for unemployment insurance in a different location. So it's very spread out. It can be hard to keep track of all the different obligations a company has and do them in order, because some have to be taken, some steps have to be taken before others. There can also be registration requirements for paid leave authorities. So states that require paid leave approach this differently. One approach is that the state law says that employers have to provide a certain amount of paid leave to employees, and that's paid from the company to employees through their regular payroll procedures. Another approach is that companies have to provide paid leave, but the pay actually comes from the state paid leave authority. So they're getting that additional paid leave money from a different source than their regular paycheck. And in states like that, there are often registration requirements with the state paid leave authority. So for example, in Connecticut, there's a Paid Family and Medical Leave Act that allows employees to take paid leave for certain events under the FMLA, the Connecticut FMLA, and the Connecticut Family Violence Act. And that payment is made from the state. So employers that have one employee in Connecticut have to register their business with the Connecticut Paid Leave Authority. And then after registering, they have to withhold 0.5% of an employee's pay from payroll deductions and then remit those contributions to the state paid leave authority. So that can be an additional registration and cost implication for companies that they need to think about. There can also be other benefits that are required in certain states. And Josh will get into this in more detail, but I wanted to flag a couple that aren't necessarily employment policies that you typically see in a handbook. Like California, for example, has a 401k program that requires employers in California with 5 or more California-based employees to either have a qualified retirement plan in place, or they have to register for the state Cal Savers program. So if there's an employer in California that has 5 or more employees and doesn't offer that plan, they have to register and allow their employees to participate in the state program. And this is a newer program that's being phased in California. The final deadline for compliance is this upcoming June. And that's for employers with 5 to 49 employees, but employers with 50 or more employees in California must already be complying with this state law. And that means that every employer has to report to Cal Savers, and they either have to register to participate or they have to report that they have a qualified retirement plan and they're exempt from participation in the Cal Savers plan. So that's another requirement to keep track of among so many other requirements for companies that are trying to stand up a program to hire an employee in a new state. Next, there's tax implications of hiring an employee. And as I've talked with our general counsel and with other companies, this can often be the gatekeeping item of whether or not to hire an employee in a new state is what are the tax implications? Particularly sales tax tends to be a big one because it can be such a cost to the company by triggering that sales tax obligation. So any state that has an income tax requires the employer to withhold income taxes from an employee and remit those to the state. There are a handful of states that don't have an income tax where this obviously wouldn't be a requirement, but the rest of the states, a company would need to register to withhold income taxes and then communicate that information to the payroll company or the company's internal payroll team to go ahead and do those on an ongoing basis. And then the sales tax issue is particularly important because companies have to pay sales tax to a state where they have a nexus. And we know that prior to 2018, a company had to have a physical presence in a state in order to have a sales tax nexus there. So they had to have some sort of physical connection, whether through an employee or an office or visiting that state routinely to have that nexus. But due to the Supreme Court's decision of South Dakota versus Wayfair in 2018, companies no longer need to have a physical presence in the state to have a sales tax nexus there. So after that decision, all 50 states and the District of Columbia enacted laws indicating what is an economic nexus in that state. And often it's a certain dollar amount of sales or a certain number of transactions in the state before it triggers a sales tax obligation for the company. So if a company is not already paying sales tax in a state, by having an employee there, that automatically triggers a sales tax obligation. So the company would need to register for a sales tax license or permit and then withhold sales taxes and pay those to the state. And this can be from what I've heard from our general counsel and other companies, this can often be the number one item that companies look at when deciding whether to hire an employee in a new state or allow an employee to relocate there if there are sales tax implications. There are certain kinds of sales, such as the sale of services, that may not be taxable in the states, but state laws differ on this point. So that's something that companies need to really dig into and understand. What are the sales tax obligations there? How are they triggered? What is the sales tax rate? How many sales does our company have there? And really conduct that analysis before deciding whether to hire or allow an employee to relocate to that state, because it could be such a cost to the company. And even if the sales of the company's sales in that state are exempt, the company might still have to file periodic sales tax returns indicating that there are no taxable sales. So this is a really thorny area that can be complicated and expensive for a company and often gets kind of the most attention when hiring employees in a new state. And then finally, I just wanted to touch on there can be county or local laws that have different requirements. These are all state level that we've just talked about, but there can be additional taxes or leave or minimum wage or registration requirements at a local level. And one of the ones that I think is most interesting are how some cities have requirements for employees to obtain a home occupation license or permit by working remotely from their own home. So this is an obligation that companies might not be thinking about, but in Santa Clarita, California, for example, employees have to obtain a home occupancy permit, and telecommuting for their employer is one of the listed purposes for which an employee would need to obtain this type of home occupation license. So oftentimes I think about home licenses as somebody who's running a business from their home, and it certainly includes that, but it could also extend to employees who are in their home office working for an employer might still need to get a home occupation license. And that really depends on the city or even county law. So there's so many levels of federal law, then state law, county law, and even city law that might have implications for employees working in new states. There also might be health permits or occupational license that companies need to think about. I'd like to turn the time over to Josh, who has been instrumental in researching state employment laws and helping us build up our employee handbook and our new hire employee tool set. And he is an expert on this matter and excited to talk to you about what different policy requirements a company might have in new states.
Thanks, Adrian. And you guys might recognize this slide from Ryan's presentation a little earlier. Now, when it comes to hiring in a new state, you don't just need to worry about these registrations like sales tax or unemployment insurance like Adrian's been talking about. You also need to consider, as Ryan mentioned, some state-specific policy requirements. Now, at the federal level, there is a baseline of policies that all employers are responsible for implementing, like the FMLA or federal minimum wage. However, there are a myriad of policies that are required by the states. And as you can see, this list of a couple of states here, they have widely differing requirements. As you can see, California has this long list of requirements, and that's as you may come to expect from California. They are hyper legalized. Nevada and Utah have some less cumbersome requirements, but they are still kind of unique among the states. As you can see, above the state-specific requirements for leave times, there are different qualifying circumstances and whatnot. One thing you might note is that jury duty leave is relatively ubiquitous among the states. I think the only state that does not have a jury duty leave requirement is Montana. So this is one policy that's almost required everywhere. Even so, each state's jury duty leave requirements are going to vary, between states. So just the fact that a jury duty leave is required does not mean that the same requirements are going to be applicable in every state. For instance, some states, it's only applicable to employers with over 10 employees. In some, that number will go down to 5. Or some states may require that employees are provided paid time off for jury duty. Some don't require it to be paid. And so as you can see, there are various changes there. You can also see from this slide that many other policies have employee thresholds before they become applicable, like Utah's immigration compliance, Nevada's emergency worker leave, and California's pregnancy leave. So that's just because a type of leave may be required, your company might not be applicable because they don't have the right threshold number of employees. And these kind of things, again, vary state to state. And so it's important to take note. Now, speaking of leave policies, states have very different requirements for all types of leave. And as we can see here, like I mentioned before, some states have their own family and medical leave acts. Like in addition to the federal FMLA, you also have California, Connecticut, Washington, D.C., Maine, Rhode Island. All of these states have their own acts for FMLA, requiring different amounts of leave to be provided to different employees. And those vary also based on different qualifications of the type of leave people are trying to take. And there are many types of state-specific policies, in addition to the state FMLA programs. I listed some here to give you an idea. So some like bone marrow leave, which is leave often provided for employees to donate bone marrow. And it's often included with blood and organ donation, but sometimes it's separate and it's kept by itself. As you can see, it's required in various states there. I'm not going to list all these because you guys are going to get the slides afterwards, but you can see that there are a number of states that specifically require that bone marrow leave be provided for employees who wish to donate, but it's far from uniform. Another common, excuse me, another common state required type of leave is leave for employees to perform their duties as a witness in civil or criminal trials. And this type of policy is sometimes also included as a part of a state's domestic violence leave. It's really just so that people can take part and that they can be a part of the judicial process. Again, I'm not going to list all the states here since you'll be getting the slides, but I just wanted to illustrate that there are a good number of states that require it. And it's something you really need to keep in mind when you're hiring in a new state, is whether you have these policies in place and whether they are as applicable in the state that you're hiring in. One final type of leave that I wanted to discuss is election judge leave. This is required for employees to operate as election officials. And you can see it's required in Alabama, Delaware, Illinois, Nebraska, Ohio, Virginia, and Wisconsin. Now, again, it's not a type of leave that's required everywhere, and its requirements can vary even between those states that do require it. For instance, some might require paid leave, some might not, and some might have a number of hours required to be provided, and some might determine how much time is given by the day. And so, again, one more thing you just need to keep into consideration. Some of these types of leave only apply to employers with a certain number of employees, like we mentioned earlier. For instance, South Carolina, only employers with over 20 employees are required to provide bone marrow leave. Even though it's a required policy, it might not be applicable. So there are various minute pieces of information that are important to recognize when hiring in a new state. Now, it's important to recognize also what types of leave are required in your state, because failure to comply with state policies can lead to both civil and/or criminal penalties. For instance, in Oregon, failure to allow employees to take sick leave, or if employers don't pay employees for the full amount of sick leave used, or who otherwise penalize employees for using their sick leave, they'll be found in violation of these leave laws and can be fined up to $1,000 for each violation. And in Maine, employers can be subject to criminal penalties for violations of required jury service policies. So if an employer deprives an employee of maybe health insurance coverage or employment benefits that they otherwise might be provided, they can be subject to criminal penalties and civil suit for lost wages and even attorney's fees from the individual employee. Now, just implementing these policies and knowing that they exist is one thing, but there are also requirements for communication. You need to communicate to your employees what policies you have and what rights they're given. So if we move to the next slide, we can talk about what notice requirements there are and how they vary a little bit among states. So for instance, here we have DC, Georgia, Maine, and Oregon. They have specific notice requirements when an employee is being required to sign a non-compete agreement upon hiring. And as Ryan mentioned, those are very different as it comes to different states. For instance, Oregon requires that an employee who's being required to sign a non-compete agreement be provided with that agreement at least 2 weeks before their start date. And while DC has implemented a new outright ban on non-compete agreements, information about that ban must also be provided to all employees across the board. So you still need to tell employees these things are unenforceable, even though you can't provide it to them. It almost seems irrelevant, but there are many types of notice that are required. Another one is wage notice. This kind of notice provides employees with information about how they'll be paid, when they'll be paid, and how much they're going to be paid. These are often required to be signed by the employee and serve as proof that they have had written communication about their pay with their employer. Now, these notices are also often required to be provided in the employee's native language. So that is going to require communication back and forth, knowing who you're speaking to, what kind of information they can interpret, and providing it to them in that language. And those requirements are going to vary by state also. I've listed some states there that require wage notices on the slide, and you can see them all when we send out the deck to you. But in all, there are 19 states with such a requirement. And those have all been noted in our new hire tool. So it'll be something that you can take a look at, check it off your list if you see that you are or are not a state that requires those kind of notices. Now, we've discussed that notice is sometimes required, but one issue that comes along with that is the form. Now, there are, of course, federal notice requirements, but states, again, have their own requirements, and it's important to know what those are. Now, I'm going to talk about what those requirements are in a minute, but first, I'd like to get some information from you about how you deal with sending notice to your remote workforce, since that has been such a hot topic ever since COVID has driven the workforce kind of home. So we have a poll here. How does your company distribute signage or notice to your remote workforce? Do you send it individually through email? Do you maybe host it on an intranet site that you control on your own? Or is there some other way that you provide this information? Now, I'll give you guys a few more seconds here. Okay, let's pull up the answers here. Okay, all right, so email is about 39%, intranet 45%, and other 16%. That's a little surprising. I kind of expected email to be the more common type of communication system, but the intranet site hosting that is a very good type of communication system, and I'll explain why that is here in a second. So let's pop over to the next slide. So as we're talking about this notice, there are many laws and policies that are required to be communicated, and some of which are mandated by federal law, like OSHA safety requirements. Most of the time, this communication is accomplished by posting signs with relevant information in common areas so that employees can peruse that information when they have the time. There are some laws that are nearly always required to be communicated, like the top half of those we see on the slide: child labor, minimum wage, human rights, etc. And it's true that those are pretty universally required to be communicated, but what information is communicated obviously varies by state, because the child labor laws are going to be slightly different. Minimum wage is going to be a lot different. That's one of the most variable on this list. We know that minimum wage is set at $7.25 federally, but each state determines what their own wage is. Some states, like Alabama, choose just to follow federal guidelines, and others might choose a higher wage, like California set their minimum wage at $14 an hour for employers with 25 or fewer employees, and $15 for employers with more than that. Now, as we discussed before, different states require employers to provide different types of policies, like the lower half of the list. So we've got blood donation in New York, domestic violence in Ohio, the right to know in Pennsylvania. That's the right to know if there are like hazardous substances in the workplace. And the right to be free from pregnancy discrimination in Rhode Island. Those are just a few specific policies that are required in those states that aren't required in others. These policies are also required to be posted in a common area for employees to see. However, this is where that poll I asked you guys to take becomes interesting. As we know, in our current workforce, more and more jobs are being performed remotely, and there's no longer really a common area for employers to post this kind of signage. There's not a break room for people who work in a different state. But the law still requires that the information be communicated. So how are we supposed to do that? The short answer is we're not sure. States have yet to really legislate this issue and discuss it in depth. Since most of these laws were created before the first portable computer was even invented, how employers might provide this notice to a remote workforce has hardly been considered. We have some federal guidance provided by the Department of Labor. The DOL has recognized that more employees are working remotely, and has determined that electronic postings can serve as a suitable supplement for physical postings, and especially for employees who work exclusively remotely. Now, the DOL makes some distinctions about whether sending information via email or hosting that information on an intranet site, like we saw that most people do here. They made some distinctions about what's more appropriate in given circumstances. But one thing that's made particularly clear is that it's important for employees to have ready and easy access to whatever information whenever they need it. There really shouldn't be hurdles for them to have to jump in order to find the information they need. They shouldn't have to ask for permission or jump through any hoops. Now, because states haven't really addressed this issue, this is good guidance to follow until the states decide for themselves exactly what they want. And when that happens, we're going to be sure to update our new tool with that most current information to allow you to see how you should be posting this information. Now, to move a little bit away from notice, states also have their own requirements when it comes to payment frequency. So as we see, states have their own ways of dictating how often employees must be paid. For instance, Illinois requires that employers pay employees at least semi-monthly. Now, this language is what's actually used in the statute. Kansas requires they be paid at least once a month. New Mexico says that it can't be more than 16 days apart, and Oregon dictates that employees need to be paid at least every 35 days. Those are just a few examples, and they can vary based on the type of work being performed, the salary threshold that employer is making, or employee exemption status. And so, again, this is just one more thing that employers need to consider when it comes to hiring in a new state. Does your current pay schedule match up with your new requirements? And related to pay, I'd like to talk next about overtime. There we go. So just as there are state differences in minimum wage, there are differences when it comes to overtime requirements. Of course, we have the federal government requiring non-exempt employees to be paid at 1.5 times their normal rate for hours worked over 40 hours in a week. But as with everything we've been talking about today, that changes when we talk about individual states. In Nevada, for example, employees need to be paid at 1.5 times their regular rate for over 40 hours worked in a week and for hours worked over 8 hours in a 24-hour period. Similarly, in California, employees need to be paid at 1.5 times their regular rate for their hours worked over 8 hours in one day and double their normal rate if they work over 12 hours in a day. Now, California also has differences when it comes to the work week, but I just wanted to illustrate some of the minute differences you're going to see when you cross state lines and hire in a new place. Now, one consideration that's important for employers to consider in determining whether their employees need to be paid overtime is their exempt status. And while our new tool flags this issue for consideration, the exempt, non-exempt dichotomy is one that can be more complicated than our current tool is capable of expressing. And that's why we're working on a new tool, in addition, that can help employers make that determination. And that one is still in production, so stay tuned. But those are just a few of the things that you're going to need to consider in hiring in a new state. These are all issues that we flagged in this new tool that we've been discussing today. Now, I know that I've seen some questions come in through the chat and through the Q&A feature, and I wanted to see if maybe Ryan and Adrian saw anything we should talk about here at the end.
Yeah, thanks a lot, Josh. We've had a ton of questions come in through the Q&A and the chat. We really appreciate how interactive it's been. One issue that's come up several times is we've had people say, how do I know if people are moving? Or what do I do when I find out that people have moved without telling us? And that is one of the reasons that we recommend that companies have a relocation policy that requires employees to let you know before they move to a new state, because of all the things we've talked about today, because it can be a real headache for you as an employer if you find out that a year ago or a year and a half ago at the start of the pandemic, you had one of your employees move to a new state and they've been working there for an extended period of time. I actually heard just anecdotally a friend say that at his company, they had an employee they hadn't seen for a long time, and he had actually moved to a foreign country, which I think sort of compounds the issues. So yeah, lots of tricky issues there, but made simpler if you have a relocation policy that requires your employees to let you know if they move. Adrian, I know you've been furiously typing answers to questions. Any other questions that jump out to you that might be helpful for us to answer with the group?
Yeah, I mean, I think the question of what can we do if an employee relocates without telling us is a tricky one, right? You want to preserve the relationship with your employees, specifically in a tight labor market, but it can have big implications for a company. And often those implications trigger on day one of having an employee there. So if you're not finding out the employee is relocated until 30, 60, 90 days later, I mean, that could trigger some serious liability for the company, and the company might not be prepared to handle those cost implications of having an employee in that state. So I think having a clear policy that says what the expectations are for employees, but also communicating why. Why does this matter? It's not for the company to be burdensome and limiting employees. It's because it has serious implications for the company that they need to be prepared for and maybe approve in advance, or at least have notice in advance that an employee is relocating. And then also in the policy, it's helpful to talk about if you don't follow these procedures, you could be terminated. And we've seen companies that have to terminate employees because they just can't handle having an employee in that state. They're not prepared for the cost or other employment implications. And that's really an unfortunate situation to hopefully avoid by having policies or communication in advance so that that doesn't happen, or to make the process easier if it does happen.
Yeah, great point.
And I think you shared an anecdote earlier about the overtime issues, just knowing what they are when you move across states. You said that there was a dentist who moved to California not knowing the overtime laws. And while their office was only open 4 days a week, they were open the entire day. And employees were often working over those 8 hours, and they didn't know they needed to pay overtime for over 8 hours. They were only accounting for 40-hour weeks. And so those are just considerations you need to keep in the back of your head.
Yeah. Yeah, definitely. The other question we had several, I guess I'll say issue we had several questions about was registering as a foreign corporation. And someone pointed out that it's difficult because in some states it's with the Department of State, with others it's the Department of Labor, others have specific offices. The thing I think that's difficult about this issue is that it varies so widely from state to state. That's similar with some of the COVID issues that we've dealt with. So I think that's a real challenge. We've come up to the end of the hour. I guess one other question that we had multiple times was, how can we learn more about these tools you've talked about? Feel free to visit us at SixFifty.com. We have a chat there. You can chat with someone. We're happy to show you these tools if you're interested. We really appreciate all of you for joining us on this webinar. It's been an interesting discussion. I think we'll have follow-up webinars on many of these different topics where we'll be able to go into more detail. But this is an interesting area that I think affects a lot of businesses, and we've enjoyed putting this on. We hope that you'll join us for future 650 webinars. And again, if you're interested also in seeing this new pro bono Ukraine tool that we've created, feel free to visit us at 650.com. And with that, we will sign off, and we hope to see you at a future 650 webinar.